The defendant knew what conditions he must follow and abide by. He knew he was a convicted felon who was legally forbidden from possessing any firearm for life for any reason. Bears, squirrels, protection from burglars, or zombies makes no difference.
The judge made it clear, no sugarcoating. This isn't about hunting season or home defense. For felons, possessing firearms results in a lifetime ban. Yes, that includes even hypothetical threats like zombies. Ever wonder why felons lose that right permanently? It all comes down to public safety. And this case shows exactly why.
On the record, in the matter, 24 CF 143, State of Wisconsin versus Michael Winquist. The state appears through District Attorney Kevin Schmidt in person. We have Mr. Winquist appearing in person in custody with counsel Eugene Harrington. We're set today in this matter for an oral ruling. The parties have requested that the court review and approve a plea bargain, a plea deal that has been presented. We are in victims' rights compliance.
Yes.
All right, we are in victims' rights compliance at this time. Although I'm going to be making an oral ruling right now, I'm only going to give you a gist or a brief summary of what my decision is. I have a full written decision that I will sign immediately after this hearing, and the parties will have access to. The reason why I am not going to submit it right now, or I'm not going to read the decision because it is 13 pages. So it gives much for the parties to review and to discuss, but I'm going to say this was a very difficult decision to make.
Here's where it gets serious. The judge appears visibly conflicted. This isn't just a routine decision. The alleged crime is deeply disturbing, and when a juvenile is left emotionally scarred, the implications go far beyond criminal injustice. We're talking about lasting human trauma. Ever wonder if plea deals sometimes let dangerous individuals walk free? Stay with us. This case is anything but simple.
Of very heinous crimes that cause significant and permanent physical and emotional harm to a person and left a juvenile emotionally scarred. I have two attorneys whom I respect thoroughly, who understand the law and know the facts of this case thoroughly, more thoroughly than I have been provided. I only have access to the facts in the criminal complaint, the statements made during the hearings by counsel, and the facts that as they are outlined in the defense's stipulated facts memorandum. A plea bargain requires a court to have thorough review of what it has in front of it. If a prosecuting attorney has agreed to seek a charge or sentence concessions, they must have the approval of the court, and the court must personally inform the defendant that the prosecutor's recommendations, that the recommendation, this joint plea bargain, is not binding on the court. This bargain, this plea deal, must also be evaluated to ensure that it serves the public interest. The court's duty and role is to safeguard the public interest, to substantially ensure the benefits and the advantages to the public. Deciding whether to reject a plea agreement is firmly within this court's authority and discretion.
Something many people don't realize. Judges have the power to reject plea deals even when both the defense and prosecution agree. It's called judicial discretion, and it's the judge's responsibility to protect the public interest. Surprising, right? The takeaway: plea deals aren't automatic giveaways. The court still holds the gavel when it comes to deciding what's fair. Next.
It is vested in me, the judge, and the circuit court to determine what pleas do serve the public interest without allowing the court to interfere with the prosecutor's authority when the prosecutor decides what charges to file and whether to file charges at all initially. There are certain factors that a prosecutor considers when deciding whether to file charges, and these factors somewhat overlap with the court in determining public interest in whether to accept a plea. These include such things as extent of harm caused by the offense, threat posed by the public or to the public by the suspect, the ability and willingness of the victim to participate, the disproportion between the authorized punishment of the particular offense or the offender, possible improper motives of the complainant, cooperation of the suspect defendant with the arrest and prosecution, the possibility of a likelihood of prosecution by another jurisdiction. That doesn't affect our case. Accordingly, these factors that a court must weigh when defining a public interest and what interest is involved, it varies from case to case. I must look at each of the facts and look at each of the cases separately. One appropriate factor for one case may not be something considered in another case. Things that the court looks at and reviews would be such things as viewpoints from law enforcement officers, as well as other things, which it's not an exhaustive list, but I must take into account the public's right to have crimes that are actually committed to be fairly prosecuted and to protect the rights of third people.
Here, the judge is carefully weighing everything from the defendant's background to society's expectations of justice. This isn't just about legal outcomes, it's about public trust. People need to know that serious crimes won't be quietly overlooked. Ask yourself, if this were your town, would you want this plea deal accepted? Next,
the court must evaluate the defense attorney's reasoning and arguments and recommendations and balance that with the public interest and with the prosecutor's arguments to seek a fair prosecution. Other components of a public interest that the court must consider include whether the defendant has voluntarily and intelligently entered into a plea agreement, plea bargain, whether a factual basis exists for a guilty plea, the general public's perception that crimes should be prosecuted, the interests of the victims, the court's ability to dispose of a case in a manner to commiserate with the seriousness of the criminal charges, and the character and the background of the defendant, and the plea's usefulness in securing a legitimate and important prosecutorial interest. It has been observed that there may be situations where the public interest might be better served by having a case tried rather than having it disposed of with a guilty plea. The court has reviewed the facts of this case, the information, the complaint, the transcript for the preliminary hearing, the defendant's admission of facts, and the defendant's memorandum regarding the public interest of the plea. I've also heard very thorough, thought out arguments by both attorneys and an impactful statement by the victim. The court wrestles with the notion of accepting a plea in totem. That means to accept the plea as it is fully presented to the court as a complete agreement. Standing alone amendment and the amendment to count one may likely be appropriate and would meet the public interest consideration. The rest of the plea agreement causes skepticism and
the moment when pressure builds, the judge is raising concerns about parts of the plea, calling them uncertain and potentially problematic. His response goes beyond hesitation. It's grounded in a strong sense of duty to protect against future consequences. There's a sense of tension in the courtroom. Will the court deliver a message of accountability or risk setting a troubling precedent?
The court has a responsibility under case law and its higher courts to reject a plea agreement that does not serve the public interest as a whole and not simply in parts. The plea agreement as extended and when compared to the allegations of the criminal conduct with the facts available to the court gives the court apprehension. What jumps out in the record is the nature of the facts within the criminal complaint and the preliminary hearing transcript regarding the specific allegations of the defendant's criminal thinking. His blatant, utter disregard for public safety, in addition to his complete and total disrespect for the law. There are situations, again, where the public interest is better served to have a case tried rather than accepting a guilty plea and disposing of a case if the plea agreement as a whole is not appropriate and does not meet the public interest. The essence of this case remain: the defendant was not legally allowed to consume alcohol due to being on active probation with an absolute sobriety condition. He frequently binges on alcoholic beverages and is often intoxicated. He cannot legally own or possess any firearm because he is a convicted felon. He either has been diagnosed with or shows symptoms of PTSD from his military service and other life traumas, and did not seek therapeutic or other medical services to address it. He is aware of, or should be aware of, his history of experiencing a sleepy, dream-like state, which is unpredictable and has violent outbursts upon sudden awakening. And worst of all, he unlawfully keeps a loaded firearm next to his bed, and throughout the house has multiple other firearms stashed away. And he is fully aware of all of the above. The defendant's knowledge of the above, combined with the defendant's intentional conduct and behavior of disregarding the law and violating probation conditions, not only puts the community at risk, but also creates a safety hazard with the potential for a significant probability of death or injury to himself or others. Taking all into account, combined with the victim's allegation of the shooting, the court is concerned that accepting the plea deal as it has been extended would convey an undesirable message to the public, suggesting that the conduct is not as horrific and gruesome as it may have been. The plea would lack the deterrent effect needed to prevent others from engaging in similar serious criminal conduct and behavior. The court need not accept the plea offer as presented unless the court is convinced that the state and the defense with certain facts exist. If the district attorney is publicly stating that the state cannot prove in a court of law beyond reasonable doubt that an impartial and unbiased jury of the defendant's peers would find the defendant engaged in allegations related with each, and I am specifically stating each, charged account or any associated subsequent or lesser offense, that would be one thing. However, with this case, the attorneys are simply informing the court that considering the facts and the evidence, count 1, first-degree intentional homicide as an attempt, is not the accurate charge, as the evidence points to a lesser included charge, and a more appropriate charge would be, as the parties have agreed, second-degree reckless endangering the safety with use of a dangerous weapon modifier. And that may be accurate and true. The court notes that, as the facts are outlined in the case, the modifier is, for the most part, meaningless and does not increase penalties, sanctions, or otherwise. Additionally, as part of the plea bargain, the defendant would plead guilty to only one count of felon in possession of a firearm. The remaining 6 Class G felonies for a felon possessing a firearm would be dismissed and read in, along with the other misdemeanor count for operating a firearm while intoxicated. Again, the attorneys are not telling the court that the other 7 criminal charges cannot be proven beyond a reasonable doubt, only that count 1 is not accurate and it is not the correct criminal charge based upon the facts and the evidence of the case. The maximum possible penalty the defendant would face with the plea deal would be 12.5 years of incarceration and 5 years of extended supervision. Even if the matter proceeds to a trial, as it is charged, and if the defendant is found not guilty on count 1 as charged with no lesser included, if found guilty on the remaining counts and charges, the defendant would face a maximum possible penalty of 35 years and 9 months of initial incarceration with 35 years of extended supervision. This is a significant reduction in the incarceration length hanging over the defendant's head. The court is looking at all of the information and the arguments and hearing the impact of the victim and the impact of the juvenile victim. And in viewing the gravity of the offense, if the facts presented to the court are accurate and factual, this case is so serious and so severe that it would depreciate the seriousness of the offense and promote disrespect for the law if the court accepted the plea deal. Further, it would not promote a public interest or be a deterrent factor to others. Even though the defendant is making concessions to plead to a serious charge and is accepting responsibility for some of his conduct and actions, the plea would not have the deterrence effect to prevent others from engaging in similar criminal thinking and a total disregard